Today, the 14th of August, we're conducting this video just to inform the members of the in principle enterprise agreement. I've got Barry Sidebottom here assisting me, and Barry may interject at times and ask questions, common questions that have been asked by some of the membership around the state. This video will be broken up into three sections. The first section is a bit of an introduction in regard to how we got to this position. Second part will be about some of the details in the agreement, and the third part would be about the voting and the outcome of the voting if the vote is rejected or if the agreement is rejected, and where to from there. So to kick it all off, as members would be aware, we had a general members meeting on the 4th of August at Trades Hall, attended by about 438 members. As you'd be aware, there were a number of options put up on the PowerPoint presentation. All of those options were rejected. At that stage on the 4th of August, members would have been aware and were made aware on the day that we had to be involved in a compulsory conciliation process of 21 days, conciliation before Fair Work Australia. We still had 7 days to go between the 4th of August and the 11th of August, and we continue to try and negotiate a better possible outcome with Ambulance Victoria. We did continue those 7 days of negotiations, and at 2 minutes to midnight on the 11th of August, an in-principle agreement was reached with Ambulance Victoria and the state government. We believe that that in-principle agreement was negotiated to the best possible position under the circumstances. I know members may not be satisfied with that, but failing that, we would have been faced with, at midnight that night, going straight into an arbitration, not at that particular time, but at a later date, and all of your conditions would have been put on the table to potentially be arbitrated, and certainly we believe that Ambulance Victoria would have targeted the big ticket items. So that's where we're at today. We've got an in-principle agreement. As I say, it's dated as of the 11th of August. The government has committed to back paying your wages to that date, the first full pay period from the 11th of August. The documentation, as of today, should be circulated via email from the union to all branch stations and to individuals that want a copy. By law, Ambulance Victoria have to provide you a copy of the document and have one at each workplace. And once you have that document, we would extend to the members that they should read through it thoroughly, and hopefully we'll have the rolling rate figures circulated over the next couple of days, so then everyone will have all of the information. That allows the process for voting to go ahead in a couple of weeks' time, 2 or 3 weeks' time, where it will be a secret ballot, a postal ballot that members will be sent a ballot paper out, and you will vote yes or no to it, depending on what you think about the agreement.
Steve, you said at the 2 minutes to midnight on the 11th of August we accepted the best deal they would give. Why didn't we just throw it back at them and say, we don't want this, we'll go to arbitration?
Well, obviously our concern at the time was that in not accepting the deal at midnight on the 11th, then it really didn't give our members an option to vote on whether they wanted to accept the package or have conditions put at risk by going to an arbitration. And I'm sure we would have had many members concerned that if we went straight into an arbitration and then later on they find out that some of their major conditions could be under threat and potentially may be lost, and if we did lose them, then certainly the union would be blamed for that by not giving the members the opportunity to vote on an
meeting at the Trades Hall. A lot of members were in favour of taking unprotected strike action, regardless of the consequences. Why didn't we go ahead with that?
Well, as you'd be aware, that we did have stop work action planned, and the service and the government made an application to terminate all industrial bans, and yes, that was the protected actions, and that action was going to go ahead until those actions were terminated by Fair Work Australia. If we'd proceeded with stop work action or any other types of industrial action, and the ambulance service gathered enough evidence to make a further application to seek orders against us, and if they were granted those orders, then it gave them the legal right to prosecute individuals and the union in the federal court. And of course, the penalties, the financial penalties for that sort of prosecution is $33,000 a day for the union and $6,000 a day for each individual employee. Now, you know, for us to just proceed with unprotected industrial action could have imposed serious financial penalties against individuals. And how long would individuals be prepared to stay out if they're receiving $6,000 a day fines? So the issue was that we felt it wasn't worth that risk.